Assalamu alaikum wa rahmatullahi wa barakatuh, and welcome to Legal Ease, the show that translates legalese into English. I am your host, Yumna Bhana. A few weeks ago, we looked at the Consumer Protection Act and some of the basic provisions and some of the protections that it affords to consumers. And given the nature of the topic and the popularity of the subject matter, we will be doing another two shows on the Consumer Protection Act, starting with today's show. So today's show, we'll focus a little bit on the issue of unsolicited goods, and we'll also look at different types of marketing. And next week, we'll focus on fixed-term agreements and how the Consumer Protection Act applies to those, as well as the National Consumer Commission and how that operates. We are very privileged to have with us once again in studios Nadeem Mahomed of Nadeem Mahomed Attorneys, which, if you will recall, is a young law firm that focuses predominantly on labor and consumer-related matters. Nadeem, welcome to the show once again. Assalamu alaikum wa rahmatullahi wa barakatuh.
Wa alaikum salam wa rahmatullahi khairan, and thank you for having me back on the show. I was worried after the last show that I'd have a queue of dealers and suppliers lined out outside my offices with guns waiting to take me out, but fortunately, I'm still safe.
We'll see how long that lasts. Nadeem, let's start off with just recapping what the Consumer Protection Act applies to, and then we can go on to the issue of unsolicited goods.
Okay, as you said, and obviously just to backpedal a little bit, the Consumer Protection Act, as we said, is obviously for the consumer. It's protecting the rights of the consumer, making the consumer more socially and economically well off, and obviously keeping the dealers and suppliers and those providing a service more honest and ethical in their dealings. So as I say, the Consumer Protection Act is not this big boogeyman of consumer coming to get the dealers and suppliers. It basically is saying, get your house in order, get your documents in order, get your agreements in order, make them in line with the Act, so that you don't have to face penalties and you don't have to be dragged in front of the courts, the tribunals, and etc., etc. And just like I say, making both the supplier more ethical, or keeping the supplier ethical and honest, and strengthening the rights and protection for the consumer.
Basically, it's putting into place what they should be doing in any event.
Exactly. Well, what the reasonable tradesperson or transactor or service provider should be doing in any event. Like I say, making them and keeping them honest. And that's an important principle, in law in general. Yeah,
but I think it's a very, very exciting and an important sector that's come into our law, and I'm really glad that it has. It's probably come in a bit late, but better late than never.
Yeah, and they've always been things such as manufacturer's liability, and there's always been things such as consumers' rights in terms of refunds and exchanges, but it hasn't really been straightforward. It hasn't been an enforceable provision in our law, and it hasn't really been something that the consumer can stand up and say, well, now I have my rights and now I'm going to enforce them.
Right. Yeah. It's basically brought it all together as
correct.
Well, put it into one act.
Yes, correct.
Right. That's it. Now, unsolicited goods, what are we talking about?
Well, remember we talked about, we gave a definition of what a transaction is. We gave a definition of what goods are essentially for purposes of a transaction. Who's a supplier, who's a consumer. We gave the example of that Muslim lady walking past a shop in the plaza wanting to buy an abaya, a scarf or whatever it was for Eid's Day, buys it, either has buyer's remorse or finds out that it's not the item that she wanted to. And we dealt with whether a transaction had been concluded, whether there was accountability in terms of the act, and we dealt quite intensely with that, so we're not going to rehash that. But so basically, what is an unsolicited good? An item or goods that would ordinarily be a part of a transaction or fall within the ambit of what goods are in terms of the act, that now something has happened to those goods or those services that have made them unsolicited. When a good when an item or service, where goods or services become unsolicited, then basically the consumer has no obligation to comply with that transaction relating to those goods or items or services.
Okay. What sort of examples? What would fall under an unsolicited good?
So basically, unsolicited goods. Let's first give the legal definition as usual, and then we'll delve into the example. So an unsolicited good, a good will become unsolicited where in 5 different instances. One, where it was delivered to you periodically. So there was an agreement for periodic delivery of goods. What are periodic delivery of goods? So basically, you sign an agreement with a furniture company. They are going to supply one item of furniture every month for 10 months. For example, okay, it might be a bit of a silly example, but for example, that becomes an unsolicited good. Or where the goods are delivered at a different time, a different place, and in a different manner than initially agreed to. Those goods become unsolicited. You don't have to accept those goods, and that transaction then no longer is completed for purposes of the Act. Where the goods are delivered with a mix of other goods. So what I mean by this now is you ordered a couch, or let's make it simpler. You ordered a cell phone. All right, the cell phone arrives now at your door, but the cell phone is mixed with media players, for example. All right, now, as a consumer, you're entitled to reject total delivery of all those goods, or just keep the item that you know you've agreed to and reject the other goods. But if you decide to reject all the goods, well, then the transaction is no longer completed for purposes of the Act. Okay, so and then there's obviously certain other elements relating to unsolicited when a good or service becomes unsolicited. So when there's a material change in the agreement relating to the provision of those goods or those services. Let's deal with a service. You have a gym contract, all right? You belong to a gym. In terms of your contract, you're entitled to utilize the gym from 8 until 4 every day from Monday until Sunday. All of a sudden, the gym, without your consent, the gym then contacts you and says, well, Ms. Bhana, you now no longer are allowed to utilize the gym from 8 until 4. You now have to utilize the gym from 6 in the evening until 12 in the evening. And those are your periods of utilization. You turn around and say, well, sorry, thank you very much, but the services are now unsolicited. The goods are now unsolicited in terms of the Act. I no longer now have to comply with that transaction.
All right. I think that's spelled it out a little bit. Now, we haven't really dealt with marketing, but where is the link between unsolicited goods and direct marketing?
Just to touch on direct marketing with regards to unsolicited goods. And we'll deal with marketing a little bit more in the next segment, but direct marketing is where a good, or an item or a service is marketed to an individual, a consumer, for purposes of the Act, with the sole intention of that consumer buying or giving exchange for those services or goods, right? So an unsolicited good now is where somebody gives a consumer something. So now I give you a cell phone. I say, hey, keep the cell phone. Don't give me any money for it. Don't give me any exchange or consideration. Remember the definition of transaction. Don't give me any exchange or consideration for it. Play with it, enjoy it, and you know what, if you like something on the application that's installed on that device, buy it. It's unsolicited. You don't have to comply with that cell phone or that item that has been marketed to you.
All right, so that would be the link between those two.
Correct.
All right, let's take a break now, and when we come back, we'll finish off looking at unsolicited goods, and then we'll start looking at marketing.
Fantastic.
Stay tuned, and that's what's coming up after the break. Assalamu alaikum wa rahmatullahi wa barakatuh. Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome back to Legal Ease, where we are talking Consumer Protection Act, and in particular we are dealing with unsolicited goods and moving on to the issue of different types of marketing. I have with me in studio Nadeem Mahomed. Nadeem, we were talking about unsolicited goods and you gave some examples. Are there any other circumstances in which goods will be unsolicited?
It's a very interesting question, Yumna, because we deal a lot now with, and again, I say it again, we're going to talk about marketing and advertising, marketing mainly. But we deal a lot now with situations on the TV. Cell phone companies are advertising or marketing a certain amount of gigs of bandwidth that you can download or that you can have on your cell phone or your iPad or whatever device you have. Another important aspect of unsolicited goods is where you sign an agreement for the delivery of a product or a service. And at the termination of that agreement, they continue to provide the service or the item. Now, item, for purposes of the Act, can include, say, gigs that you're now downloading. It falls on that cusp of a service and or an item. Because bear in mind, when you get an itemized billing from a cell phone company, it says item, and then it'll say 250 gigs or 10 gigs or 250 megs, or etc., etc. So that is another situation where that item or service will become unsolicited, and you will not have to comply with the demands of the supplier if those goods or services are supplied after termination of the agreement. So exact scenario, you buy a cell phone, you then also take out 500 megs of bandwidth a month, and you say you want it for a period of 12 months. At the 13th month, you get another 500 gigs, and the price that you pay for 500 gigs is, say, 200 Rand. This is not obviously exactly what you'd pay, it's just an example, but you'd pay 200 Rand or whatever the amount would be. On the 13th month, you get another 500 gigs, and they debit another 200 Rand from your account. Is it legal? The answer is no. That service or item, however you want to classify it, becomes unsolicited in terms of the Act, and you're not obligated to comply with the demands of the supplier in that instance.
On that example, if there is a term in your contract where if you do not actually tell them that at the end of that 12-month period, you no longer want them to provide you with whatever it is they were providing you with,
yes,
and it will carry on a month-to-month basis, which I think is a standard clause, would that still be valid?
It's an interesting question again, but it's rather technical, and I'll tell you why. There's certain elements to that question which encompass certain other aspects of the law. But for purposes of the CPA, what's important there is, did you understand the contract? Was the contract explained to you in a language which was easy for you to interpret for purposes of your position? Was the expiration period, and then again, interesting question, because there is a fixed term contract, and we are going to touch on fixed term contracts in another show, but and so we don't want to elaborate too much on it, but in terms of that fixed term contract, or in terms of that contract, is it legal for them to place a burden on you which you might not have otherwise accepted? So it's a technical question, but the interpretation of which is simple. And if you remember what is the scope and purpose of the Act, and the scope and purpose of a supplier supplying services or items to you, it's that it must not be misleading, it must not be deceptive, or cause you or place you in a position which you would otherwise not have engaged or transacted in. So a short answer, my answer would be yes if the contract is fair and reasonable, but no if the contract is unfair and unreasonable. And what's unfair and unreasonable? Well, contact an attorney and let them have a look at the contract. But really speaking, as long as it upholds the purpose and the function, the main fundamentals of the reasons or the purposes of the Act, it should be fine.
It should be fine. What would make advertising or marketing deceptive or fraudulent in terms of the Act? Or
misleading, which is, in accordance with the Act. Basically, to answer the question, if a good or market, so these four elements to it, okay? The one element is that the nature, the quality, the quality or the performance of the goods or the service are different to what has been marketed to you. Then the advantages or uses of the goods as perceived by the consumer are different to what has been marketed to the consumer. The price and quality again of the good, of the items or services as marketed are different. Or any other material element or material difference between what has been marketed and what is actually produced or provided.
Okay. Were you talking about what the consumer perceived, the good to be or to give them or to provide? For example, if you've seen an advert and it's promised, the product has promised to do X, Y, and Z, and it doesn't, that's clear that it wouldn't fall within, it's falling foul of the Act. Correct, basically. Yes. But what if there's, imagery that's used and an idea is sort of planted that this is what the product does without actually saying that?
There is case law in our country that relates specifically to that. It also then gets into that whole realm of competitive marketing, competitive advertising. So it's really for advertising and the advertising standards of South Africa. Now, bear in mind, the CPA doesn't just deal with just marketing. Or if it does deal with marketing, then let's broaden the horizon of marketing. You've got the Direct Selling Act. You've got the Direct Marketing Act. You've got the Advertising Standards Association of South Africa. You've got the Direct Marketing Standards Association of South Africa. You've got, I mean, there are so many different acts and that relate, acts and principles and regulations and codes of conduct, really speaking, that relate to it. So the answer is yes. If you, as a reasonable person, perceive an item to do a goods or an item or services to be able to do something specific, as the reasonable person sitting at home on the couch looking at that marketing device or that advertisement, then that is what it should be able to do.
Nadeem, let's leave it there and take the break now.
Perfect, thank you.
Assalamu alaikum wa rahmatullahi wa barakatuh. Stay tuned and we'll be back shortly. Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome back to Legal Ease. We are talking about the Consumer Protection Act, and just before the break, we started looking at the different types of marketing, which we'll continue doing now. Nadeem, there's an interesting concept. It's called bait marketing. What are we talking about?
Exactly that. I'll give you a worm on a hook. It looks fat. It looks juicy. You're a fish. You take a bite of it, but actually it's filled with air. That is exactly what bait marketing is, the long and the short of it. So basically, a supplier or a service provider will present an image to you of an item that can do X and Y, can perform a certain function, that has great advantages, that might even make you money, and at a specific price or at a specific price. When you walk into the shop to go and inquire on it, they say to you, well, this item, it's not really available. Come and look at this item. Bait marketing. Or this item, and bear in mind, and I'm going to get to that now, but bear in mind, no limitations have been in place on that item, but this item no longer in store, but we've got this item, it's even better than that item. Why don't you take this item? Or even worse, the price that was advertised was only for a specific period of time. It's a little bit more expensive now, but also it's a little bit better now. We've worked out the bugs of the item or the good. All that is bait marketing, and it's illegal in terms of the act, and it's not allowed to be done. When you get induced into wanting to purchase something, remember, a transaction has been created. If you walk into that shop with the intention of purchasing that item or acquiring that service for exchange or consideration, as we mentioned, a transaction has been enacted. And once a transaction is in place, well, then they're obligated to comply with the act. And if they don't comply with the act, well, then they fall foul of the act and can be hauled in front of the National Consumer Commission or National Consumer Tribunal or a consumer court, or whichever the investigator at the NCC suggests is relevant.
All right, and another type of marketing, talking about negative option marketing, where you've got to, specifically refuse an offer, as it were, for that not to come into effect, or for you not to be held liable for it. How does that apply now in terms of the act?
Are you referring to negative option?
Yes.
Well, negative option marketing essentially then is that the promotion or the provision or a service or an item to a consumer, or modification of an agreement or entering into an agreement with a consumer, between a supplier and a consumer, that will come into effect unless the consumer advises implicitly or expressly that he does not want to be part of that transaction. That's negative option marketing, and it's not allowed in terms of the act. What does it mean, really? Let's look at an example. Sorry, I can see you were about to ask that, but let's look at an example. Pre the act, I, for one, was an individual whose cell phone number appeared on 100 different databases of 100 different insurance companies or 100 different cell phone companies, or dealers who offer a certain service for a certain type of vehicle, and you would get blasted with all these cell phone SMSs coming in, and the SMS would say, we found your number on a database. We believe that you were interested in a certain type of insurance. If you do not reply no to this SMS, well, then you're entered into an agreement. Nonsense. It's illegal. It's not allowed in terms of the act. And besides, why should I pay 150 to tell you that I don't want to be part of the agreement when I was never marketed that agreement? I don't understand it, or that service rather. I don't understand it, and I simply don't want it. It's entrapment in a sense, if you look at it like that.
Absolutely, but and what you're saying is that even where it asks you to do a specific thing, there's no obligation on you to do anything at all.
Post the act now or after the enforcement of the act, if they send me an SMS and say reply yes or no to opt out from this promotion, if I don't reply yes or no, there's no liability or accountability or obligation that I owe to that service provider or supplier or whoever the person or the entity is.
Okay. Nadeem, a particular issue that I have, and I think probably a lot of people have, is the issue of telemarketing. People phoning you and wanting to market something or other to you. Is that fine? Is that fine for them to just get your number off a database and be contacting you and punting their goods or services?
You will see a dramatic change in the obtaining of information for purposes of database from when the act started being thought up and when it started coming into the media that there was this act, the consumer boogeyman, as you like to call it, for suppliers, was coming now into enforcement or coming into enactment. You saw a dramatic change with promotion girls and guys at stores or at outside a convenience store, outside a shopping mall or whatever it is. Now they would come to you with a pamphlet and they would say to you, sorry, there's two answers to the question if you don't mind. The first aspect is how do they get your number in the first place and are they allowed to contact you on that number? The second thing is when and how are they allowed to contact you on that number? So now you get a lady will come to you. She's probably skimpily dressed if she's going to a man, or he's hunkily dressed if he's going to a woman, and he says to you, can we get your number? There's an amazing promotion going on for this new hair product. Can I get your number and I can give you a call? Now you have to sign and you have to say, I confirm that my cell phone number will be provided to XYZ Pty Limited for the purposes of a promotion of a specific item or service, and that they will contact me via SMS and or telephone call in accordance with the act.
Okay.
And I've got to sign that. And if I don't have that, then what they're going to do is they're going to have to prove to the consumer court why they called me, how they got my number, and were they allowed to give me a call in the first place.
All right. I think that answers a lot of it, and I can now tell them to go away because I didn't ask for them to specifically
absolutely. And if they do call you, just very quickly, they have to call you at a specific time, and they have to advise you when they call you that they are calling with promotion of a service, that you have given your number to them, and that you've consented to them contacting you for a specific promotion service. And if after they say to you, can I have a moment of your time, you say no, they've got to put the phone down instantly, practically.
Great. Nadeem, lastly, let's just touch on direct marketing.
Direct marketing, basically the aim of direct marketing is where a promoter or a service provider or a supplier that markets or advertises a product to a consumer with the intent of selling that item to that consumer, as we said in the instance of unsolicited goods, right? So I come to you, I say to you, look at this amazing, beautiful phone. It's got this, it's got that, it's got 3G, 4G, it's got, 100 megs of data, it's got this, whatever it is. Please take a look at it, play around with it, and if you like it, buy it. That's direct marketing. So now what they're actually saying is be very specific when you market it directly to a consumer. Make sure that it's in accordance with the standards of marketing, reasonable and fair marketing to the consumer. That is not misled, that is not deceptive, it's not false, it's not fraudulent.
Nadeem, let's leave it at that for today. We look forward to seeing you on next week's show, where we'll be talking about the National Consumer Commission as well as fixed-term agreements. We look forward to seeing you then.
Thank you. Assalamu alaikum.
Wa alaikum assalam wa rahmatullahi wa barakatuh. Make sure you tune in to next week's show, where we again will be talking about the Consumer Protection Act and those specific topics that I mentioned. Please email me on legalease@itvnetworks.tv or follow me on Twitter @Yumna Bhana. I look forward to receiving your comments and suggestions. Assalamu alaikum wa rahmatullahi wa barakatuh.